So, yeah, would you like to introduce yourself?
Yeah, so I'm Dr. Adrienne Barnett, and I'm a reader-in-law at Brunel University.
And I wanted to connect with you because, like I said before, I went down to the Family Court Conference in London beginning of this year. And you were there as a guest speaker, and I was intrigued to want to know a bit more about the work that you do, why you do it, and what your own views and opinions are around what is actually happening inside the secrecy of the family courts, really.
Okay, that's quite
There's
a
a lot for
broad
you there.
scope.
There's a lot. There's a lot for you
There
there.
is. There is. So I had started off many years ago as a family law barrister. I practiced at the bar for just over 30 years, for about 25 of which I specialised in family law. I did predominantly representing parents in public law proceedings, but also quite a lot of private law children proceedings. And while I was still in practice, I started doing postgraduate study and research. That's now about 27 years ago. And during the course of doing postgraduate study, a report was published, which you may be familiar with. This was back in 1996, by Professors Marianne Hester and Dr. Lorraine Radford, about domestic abuse and the family courts. Yeah. This is the first time this whole issue had kind of been highlighted and come to attention. Before that, there was no real research, certainly not in this country, about it. It wasn't something people discussed. There was this sort of almost divide between domestic abuse, or domestic violence as it was then called, and post-separation arrangements for children. This idea, oh well, he may be a bad husband, but he's a good father. And this brought this whole issue to sort of professional, political, public attention. And so I did a sort of following on from that, I did a small study looking at how barristers represent women in child contact proceedings when there's domestic abuse. And then sort of carried on doing research. I did my PhD on looking at this issue, and particularly on Practice Direction 12J, fairly soon after it first came out in 2008. And then that led to eventually end of 2013, which is, now 10 and a half years ago. I left practice and moved into full-time academia and have continued to research in this area. And sort of in the last few years broadened that out to look also at the issue of so-called parental alienation and how that factors into these cases. And also I have for some years also been looking at international child abduction and domestic abuse. Hague Convention proceedings.
We'll go on to that in a bit. How do you think things have changed from you starting that research? Do you think that it has got much better or not really? I know what we see working on the ground with victims, and I can remember kind of 2003 that things kind of shifted a little bit when fathers' rights kind of came into play, when they climbed up Big Ben with Batman suits on. I remember that very, very well. And it sort of, my opinion is, it did a total 360. it just changed everything. And I know what my opinion is on if that had been a group of women that had decided to climb up Big Ben, dressed as Wonder Woman. I know what what the scenario would have ended up like there, but I I still think that it's very, very much behind the times, and my view is that these courts need transparency, and they need to be opened up, they need to be regulated. It seems that there's no accountability anywhere for decisions that are being wrongly made. I've sat in courtrooms where judges have not even looked at court bundles, and I just think, how is that even possible when they're making decisions about children's lives?
I think it's sort of not. There isn't a sort of linear movement. I think if you take a broad overview of what's happened in the last probably nearly 30 years, what seems to happen is that there's what we called in an article that I published with Professor Rosemary Hunter and Professor Felicity Kaganas, it's almost like a cycle of failure, in that there are attempts to make improvements, but then research shows these aren't sort of happening, they're not making a real material difference on the ground. More attempts are made to improve the law, to improve practice, and it's so on, and that's how it goes. I mean, it's fair to say that that original report by Hester and Radford led to some significant changes back in, 24 years ago. There was the Lord Chancellor's, the Advisory Committee, Lord Chancellor's Advisory Committee had did a consultation, published guidelines, and at the same time we had, of course, the seminal case of Re L, in which the Court of Appeal, made it clear that domestic violence is a significant failure in parenting, and it laid down guidelines, including that if there's disputed allegations of domestic abuse, there should be a fact-finding hearing. Research after that showed that the real guidelines weren't being followed.
Yep.
So that was the first problem, sort of first indication of the cycle.
Yep.
And then you're right, at the same time, it was only a couple of 2-3 years later that, under pressure from fathers' rights groups, another consultation started called Making Contact Work. So the government had these sort of competing kind of pressures, from the domestic abuse lobby, from women's organisations, for more protection against domestic abuse in these cases, and then from the fathers' rights lobby, who effectively are pressing for 50-50 shared care. Mm-hmm. And this led to a sort of watered-down compromise, effectively. Yeah. What you got was one recognition in the Children Act that living with seeing or living with domestic abuse is harmful to children, but at the same time they did things like bring in sort of stricter measures for breaches of contact orders. And these kind of watered down compromises don't please anyone, do they?
No.
So nobody was happy with this. But then what made the real difference was that in 2004, Women's Aid published the 26 Child Homicides Report, which detailed deaths of children during contact, post-separation contact. And that's what led ultimately to Practice Direction 12J. Yeah. Because the Family Justice Council was asked to report, and they did a damning report about the failings in the system. And so the president of the Family Division issued Practice Direction 12J in 2008, and then that was incorporated in 2010 into the Family procedure rules. Subsequently, we have further research which shows Practice Direction 12J wasn't being followed. That included a large study that Professor Rosemary Hunter and I did for the Family Justice Council. Now, as a result of that, and other changes that were happening in the system, such as, the sort of change in terminology from contact and residence to child arrangements, etc., Practice Direction 12J was substantially revised again in 2014.
Yeah.
Then, there were very good changes made. Not all of them good. We still had, Scott schedules kept in. Rosemary and I were saying, you need to remove this requirement for Scott schedules. But anyway, then we have the Women's Aid 19 child homicides report 2 years later, which showed, and their Child First campaign, which showed that, nothing had changed.
Yeah.
So we had more revisions to PD12. I'm nearly finished on this history.
Yeah.
More revisions to PD12J. And PD12J is a very good blueprint. It probably needs, some refinement. But it's because of these systemic factors, which we saw from the harm panel report, that mean it is not being implemented in the spirit and the way that it should. Now, mix into this whole mix allegations of parental alienation, and that seems to be what is the biggest kind of one of the biggest barriers to really getting meaningful change in the system. Now, I can go into talk about that a bit more if you'd like.
Yeah. Because I think it's important for us to discuss that as well. Because obviously, I want to try and get things explained as much as possible to the general public, because some people obviously have got no clue about what is actually happening in the family court arena. So it's trying to, these podcasts are just trying to kind of, make people more aware of the reality of what is actually happening to victims of domestic abuse and their children, really.
Okay. All right, let's just put this in context so that one can understand it.
Yeah.
Most couples who are going through divorce or separation don't end up in the family courts. They sort things out between them. So until relatively recently, the estimates were that about 10% of separating or divorcing couples end up in the family courts. That's probably gone a bit higher since legal aid was, pretty much substantially withdrawn in 2013. And what we know from years of research is that at least 50%, and probably more like over 60%, possibly more than that, of these cases involve allegations or findings of domestic abuse. Yeah. They can involve, but it's never just a single issue, sort of risk of harm. It's often together with, there may be child abuse, child sexual abuse, although domestic abuse is by far the highest issue raised, but often in conjunction with other things, like maybe substance abuse and so on. So it's usually quite complex. Mm. But bearing in mind the high prevalence of risks of harm in these cases, bearing in mind we're talking about something like whatever it is, 55 to 60,000 children a year going through the family courts, orders for no contact are made in less than 0.1% of cases. Mm. So in the vast majority of cases, whatever these risks of harm that are being raised, some form of contact at the least is being ordered. Mm. Now, one of the sort of big problems, and the harm, just for people who may not be aware of it, we've looked at these sort of different studies, different reports which have highlighted the problems in the family courts in getting to grips with and dealing adequately with domestic violence. Probably the biggest one was the Harm Panel report in 2020, which was the result of an inquiry by the government, held by the Ministry of Justice, into domestic abuse and other risks of harm in the family courts. And that heard from a wide range of individuals, organisations, parents. They also commissioned a literature review to support it, which I did. And it's a large report. It's well worth reading. You can just Google it if you want to find it. And they identified 4 systemic barriers to dealing effectively and safely and managing risk in these cases. And the first one is this pro-contact culture, sometimes called the contact at all cost culture. The courts think contact is overwhelmingly important, that they bend over backwards to achieve it. This case after case says, stopping contact is the last resort, the court has to try every avenue, take a medium to long-term view, etc., etc. So that's kind of the pro-contact culture. That was put on a statutory footing in 2013, and 2014 it was then incorporated into the Children Act in something called the statutory presumption of parental involvement. So that's the first thing. The second thing is this adversarial system, which means obviously that whoever makes an allegation has to prove it. And then it identified all sorts of systemic and attitudinal and cultural barriers to women proving allegations, including, what you've talked about back from, the early 2000s, when these images of hostile mothers, the image of the implacably hostile mother, which kind of dominated legal discourse, public discourse, these vengeful mothers trying to stop contact. So this very idea of women involved in these cases of being untrustworthy, of being obstructive of contact, and it has a very strong hold on sort of professional and the public imagination. There's still this perception that, if parents go to court, mothers invariably win their cases and fathers are being unnecessarily excluded from their children's lives, when, as we've seen, no contact orders are made in less than 0.1% of cases. Certainly they were at the last. So those are sort of two of the barriers. What has made it considerably worse is, and you've already got these images of implacably hostile mothers, which sort of dominate the discourse in these cases. You then have allegations of parental alienation added in, and that seems to have, where we could have made progress, certainly from around 2017 when these changes were made to Practice Direction 12J, when we had the 19 Child Homicides report, when there was a lot of stuff in the media about the problems for children and adult victims of domestic abuse in these cases. There was much more understanding being generated about coercive controlling behaviour and how dangerous that is. And that could have led to a great understanding, to some cultural change, but that's been impeded to such a large extent by the introduction of this belief system of parental alienation. Now, I did the first published study on looking specifically at parental alienation and domestic abuse, although I hadn't actually set out to look at domestic abuse, but that's what it found. There was an earlier study undertaken by Cardiff University and Cafcass Cymru by Julie Doughty and others, which looked at the whole concept of parental alienation, which is a really important study. But looking at specifically the case law wasn't a major part of it. And what my study found was that parental alienation allegations were sort of introduced in the UK in sort of around about the 1990s. And just for your listeners, just to give a little bit of background about this. Okay. So this sort of idea of parental alienation started off in the United States, and it started off as something called parental alienation syndrome. And this was a term that was coined by a US psychiatrist called Richard Gardner. Now, Gardner was a very problematic individual. During the 1980s and 1990s, he published prolifically, but the vast majority of his publishing was self-published. He was appointed in a lot of cases in the US, and on the basis of his work, a lot of kids were removed from their mothers and placed in institutional care or placed with fathers who they could be at risk with. But in these states, by the sort of late 1990s, so many concerns had been raised that he was outrightly had a sexist bias against mothers. He said they were all vengeful, and allegations raised by mothers were false and to exclude fathers. In particular, he said that allegations of child sexual abuse raised in proceedings by mothers were usually false. He had a very worrying view about child sexual abuse, sort of trying to indicate that it wasn't as harmful as society seems to think it is. And eventually, Gardner's sort of parental alienation syndrome fell into disuse in the US. But it emerged in the UK in the 1990s, largely as a result of campaigning by fathers' rights groups. But in the initial years, it wasn't really raised in that many cases. And in fact, the first reported case it was raised in was Brunel, the domestic abuse case itself, back in 2000. And in that case, these were 4 conjoined appeals. They were all heard at the same time by the Court of Appeal. And in one of them, the father had instructed someone called Dr. Lowenstein, who was a sort of Richard Gardner of the UK. And he published like over 100 articles about parental alienation syndrome and wrote in very highly sexist terms. But he was discredited by the Court of Appeal in Brunel. And then after that, parental alienation syndrome didn't really make much progress. It was still raised in a few cases, sometimes by fathers who were aligned with, say, Fathers for Justice and so on, but didn't really get anywhere. Then they dropped the syndrome part and just called it parental alienation. So it started getting a little bit more traction. The court started kind of listening to it a bit. But by sort of from about 2010, for the next few years, it didn't appear to have been raised in that many cases. And that may have been because there were changes to the rules, which meant it was harder to instruct an expert in private family cases. Instead of each parent being able to instruct their own expert, the rules changed, and there had to be one single joint expert. And then you had the changes to legal aid in 2013, which put a cap on the legal aid rates for experts. So you can see that experts were starting to lose kind of work and not wanting to do legal aid work. Then suddenly, 2016, 2017, parental alienation suddenly was in the media, the news, from sort of that time on, it was raised in a lot more cases. It really started building up, and you had all these parental alienation experts coming into cases. So people saying, somebody might raise parental alienation, you do the father. In a few cases, mothers do raise it, but it's usually often the father. then wanting to bring in an expert saying, well, you know, she's alienating the children from me, this is parental alienation, we need an expert. So you get, from that time on, a lot of friends, you know, psychologists, psychotherapists, etc., describing themselves as parental alienation experts. Mm-hmm. You have a lot of lawyers saying they have expertise in parental alienation.
Yeah.
And you can see where, you know, with cuts in legal aid, and in particular, it's very, very hard for fathers to get legal aid. There's, you know, more of a market for privately paying work. And then we also started getting this issue of unregulated experts. So we've had this thing from where you have a kind of cultural context and discourse which already has these images of mothers being obstructive and hostile and so on. So it's kind of ripe for parental alienation to become so easily accepted.
Yeah.
Now, there's no systematic study yet on parental alienation, domestic abuse in recent years, but all the indications are that it's raised in a lot of cases, and that it can have really a profound impact.
Yeah, damaging.
On cases.
Yeah.
Damaging impact on cases.
Yeah.
Increasing numbers of children being removed from mothers.
Yeah. Yeah. It's yeah, I see it getting used quite a bit in family court, and I think, what's your opinion about them being opened up to the public?
I think transparency is a good thing.
Yeah.
I think it depends how it's opened up. I think the current transparency pilot is really good and is working well.
Yeah.
There's different ways
are they cherry-picked
up
cases? Are they cherry-picked cases, though?
Depends who one is asking. What I've certainly seen, and at the moment I've been doing a review of a lot of case law for a journal article I'm writing at the moment on the statutory presumption of parental involvement, which is looking at the case law on the presumption since about mid-2020. There's no doubt that a lot more first instance judgments are being published, which is a good thing. Now, one can never know, what proportion these are of the total number of cases, or how representative they are. So you can't say these judgments are all representative. You don't know how they've been picked. But it is a good thing that the courts are increasingly publishing their judgments. In the past, if you look for judgments, it would be invariably, obviously, Supreme Court judgments, the Court of Appeal and High Court. It used to be really unusual to get anything below the High Court to find a published judgment. Now, there are quite a lot of judgments published at circuit judge level, and increasing numbers of judgments published at district judge level. What I haven't seen really, though, is magistrates' reasons being published. Now, magistrates, just for your listeners, the hierarchy in courts, family courts, is that for sort of the least complex cases, they would start off in the magistrates' court. So when a case gets filed in a family court, there's an allocation judge who has to decide which level it should go to. And if it's sort of, relatively uncomplex, I mean, it may be that the parents are agreed on most things and there's just a dispute about some detail, then it would go to the magistrates. If it looks more complex, it would go to a district judge. The next tier above that is a circuit judge. Magistrates don't give judgments, they give reasons, and I have not seen a published reasons in magistrates' courts, But there are increasing numbers of judgments published by district judges, certainly by circuit judges. Often those are appeals to a circuit judge from a district judge, and so on. So I think that is good. I think this opening up the court to journalists and legal bloggers is really good.
Yeah.
I think as long as it can be done, that it protects the child's anonymity, that's a good thing.
Yeah.
I know there are some cases where parties have been identified, but I think particularly when you've got older children, they should have a say on what's being said publicly in the media about them, and particularly whether they should be identified.
Yeah.
And I think that opening up, certainly opening up the family courts doesn't mean that, any person should just be able to walk into a family court hearing. I think that would be awful for everyone. But greater publication of judgments is a good thing, and allowing journalists and legal bloggers into the courts is definitely good. What I think does still need some relaxation, and hopefully will come, is the fact that in the UK, parties to family court proceedings aren't allowed to communicate about their proceedings. Mm-hmm. They can't talk to anyone outside of a specific list of people who they're allowed to talk to.
Yeah.
It means they can't talk to journalists, and I think there needs to be some relaxation of that. They also can't talk to even to researchers unless the research project has been approved.
Yeah.
So I think that needs some relaxation as well.
Yeah, they're not even supposed to talk to the friends.
No, they're not.
Anybody, and the thing is, it's kind of, how are you supposed to seek support at one of the most stressful times of your life? When you've not been chosen to be placed into that situation, and then you're being accused of your mental health being very poor, that you haven't got capacity to make the right decisions. It's just horrendous that you can't even speak to anybody about what is happening to you. And I've heard, and it's also happened personally to me, where judges have spoke to me like, something off bottom of the shoe, and I've heard it, like awful comments to victims, and they literally can't do anything about it. They can't do anything about it, and they can't speak to anybody. I mean, it's no wonder, after the hell that they've gone through being abused, to go through that court arena and not even being able to speak about it. It's of course it's going to have an impact on the mental health, isn't it? It can't not. I don't know any victim that it had an impact on the mental health, because 95% of them are suffering with trauma, and that's another problem. A lot of professionals don't understand how trauma works, and for me, they're basically set up to fail. They're set up to fail through the current system. It's just awful cases that we're seeing coming through us, and it's just getting worse from what we see on the front line. It's just worse.
In some ways, yes, but I think one thing about transparency, increased transparency, which would also really help, is that what I can see from these more recent cases, and having this kind of overview of going back to being in practice since the early 1980s, is that there is no doubt, looking at looked at some 40-odd judgments, that, and these are not necessarily the higher courts. As I say, these are a lot of judgments from district judges and circuit judges, is that we need to recognise when we are making progress as well.
Yeah.
And these judges are showing a much, much better understanding of domestic abuse, of litigation abuse, than we ever observed in the past in these cases. There are some excellent judgments here where, there's some judgments where there's very extreme behaviour, and then, yes, the court has made findings and has recognised the effect of that and so on. But there are also some where there are what in the past the court wouldn't have recognised at all as domestic abuse. These patterns, more subtle patterns of coercive or controlling behaviour, which in these judgments they are recognising and are recognising the seriousness of. I've just been reading one where the judge was very scathing about an expert's report where the expert was assessing the father for a risk assessment and made an absolutely inadequate assessment, and the judge was quite scathing about that.
Yeah.
So I do think that it's really important to highlight instances where there has been, really good practice and good understanding, because that helps other judges and professionals as well, doesn't it?
Yeah, and that's why we need to keep creating this awareness.
Absolutely.
Yeah.
But I don't think, I think that's what had been a really big impediment, are the way in which these allegations of parental alienation, have been used by abusers. It's that's one of the huge problems. I've seen in a study I'm doing at the moment, which is not finished, so I can't give you any findings or anything yet. But certainly from this stage of the study, where we've done the first round of interviews, the level of child removal on the basis of parental alienation is really worrying.
Yeah.
The whole way these cases have gone, it's like cases can go along an expected track, and then somehow the minute parental alienation is raised, and particularly when one of these so-called experts is brought in, it just goes off on another tangent.
Yeah.
Now, having said that, in much more recent judgments, and I don't again know how widespread this is. It may be very different in the thousands of cases going on up and down the country. There does seem to be a bit rather more circumspect view being taken by some courts, saying, well, we're not happy about using these labels. Let's just look at what's going on in the case. And this is a controversial concept. Let's just stick to looking at the facts and what's going on. So, maybe the concerns are bearing some fruit. But I do think it's massively problematic that the court, we've got at the moment no way of stopping somebody who isn't properly qualified, who isn't regulated by any regulatory body, being instructed as an expert in a case. And their recommendations can have such massive ramifications.
Yeah, and it's
for families,
unbelievable.
for
It's
children.
unbelievable, isn't it, that is actually even allowed to happen.
I think it's unbelievable. If you told me 20 years ago that this is what would happen, I just wouldn't have believed you.
No. Let's move on to the Hague Convention, because I know that you've been doing a lot of work on that, and you've been away and things like that. So just explain your work around all of that and how that came about, and just explain it to general public, really, that wouldn't really probably have ever heard of the Hague Convention.
Absolutely. I mean, that as much as a lot of people, understandably wouldn't have a full awareness of the family courts, Hague Convention proceeding seems to be something that's just completely unknown.
Yeah.
So the Hague Convention on International Child Abduction is a convention that came out in 1980. And the idea behind the convention is to, if a child has been abducted from one signatory state to another, is to try and reverse that as quickly as possible. So to get the child back to the country of what they call their habitual residence, i.e. where they were living before, where they were settled before. And then if there's a dispute about who the child should live with or anything, that dispute is best dealt with in the court of the child's habitual residence. So that's the idea behind it. And the Hague Convention has been signed by 103 states internationally, including the UK, most European states, the US, Australia, increasing numbers of states have signed up to the Hague Convention. And it provides a very efficient mechanism. So each country has to, that's a signatory, establishes something called a central authority. And then it's the central authority that, goes through the mechanisms of kind of assisting, finding the child where they've been taken, getting them back. Central authorities are supposed to liaise with each other, and then they achieve getting the child back home. Now, the idea behind the Hague Convention, and what the drafters had in mind, was to try and stop the non-resident parent, usually the father, from perhaps, snatching or taking the child, say doing a contact visit, away from the child's full-time carer, usually the mother, and perhaps they were disgruntled about a divorce settlement or something or whatever, and then running off abroad with the child. So that was the situation that the draft of the Hague Convention had in mind. And in fact, Professor Elisa Perez Vera, who was the special rapporteur, one of the original team, a leading member of the team that devised the convention, was interviewed very recently, and she said, that's what we had in mind. What we now know, and perhaps this has always been the case, or perhaps this is how it's developed over the years, but from a series of reports that have been done for the Hague Commission, the HCCH, which is the central body that administers the Hague Convention, what we know from a series of reports that have been undertaken since 2003 and that are done every few years, the latest one was published in last year, is that the vast majority of so-called abductors are primary carers of the children, and in particular primary carer mothers. So it's not the non-resident parent snatching the child. It's most often a primary carer mother, and what we know is that a very high proportion of them, it's estimated about at least 75% of them, are fleeing domestic abuse. So this prompt return mechanism, that's what it's called, getting children back quickly to where they've been taken from, then becomes hugely problematic. When you've got, say, a mother and child fleeing domestic abuse, very often the mother may be going back to her home country, not always, but very often, where she's safe, where she's got family support, a support structure, she can work, and so on. And then, if the father brings Hague Convention proceedings, that's going to overturn that mother and children's lives. And it's very hard to avoid having a return order made, because the convention says that if the proceedings for the child's return are brought in less than a year after the child was removed, so within those first 12 months, then the court must return the child, unless a specific defence can be raised. Now, the defences are very narrow, and the main defence that would apply in circumstances of domestic abuse, and is the one that most victims would raise, is something called the grave risk defence. So this defence says that the court may not return the child, not must not return, but just may. So it only gives the court a discretion not to return the child if the parent resisting the return can prove that the child would be, if returned, at grave risk of psychological or physical harm or otherwise put in an intolerable situation. And the courts in most contracting states interpret this very, very narrowly. And until relatively recently, domestic abuse was not seen as giving rise to a grave risk.
Yeah.
So that's the big problem with the Hague Convention. And so you have something, what we call stuck parents, where you've had, say, a mother and children who've had a return order, they're forced to go back to the jurisdiction of the child's habitual residence, and there they're stuck.
Yeah.
Or separated parents, because of course the order is the child goes back. It doesn't say the mother or the parent with care has to go back. In most cases, the mother does go back with the child. But in some cases she can't. In some cases, child abduction in many places, including the UK, is a criminal offence. So it may be if the father's threatened, that she knows there's a live police warrant for her, then what's she going to do? And there may be other reasons. She may be at risk if she goes back. So these are really complex cases.
Yeah.
And what the courts often say is that, well, okay, they don't always say, oh, well, we don't believe the domestic abuse, or it's not serious or something. They may say, okay, if the mother's allegations are true, then yes, it's all very serious, but protective measures can be put in place in the country of the child's habitual residence, and therefore that will reduce the risk of harm, and so the child can go back. But what we know, what there's increasing evidence of, is that protective measures don't really do anything.
No. And the children don't return back, do they?
Well, the children do return back, but I mean, if a court makes an order that the child has to return back, in very many cases they've got no choice. I mean,
How common are cases like that?
Some courts don't get that many applications. The US gets by far the highest number of Hague Convention applications, incoming and outgoing applications. But it would be because it's the largest jurisdiction. But interestingly, the UK, England and Wales, should I say, gets the second highest number of all contracting states. The figures, there's a breakdown in the figures in this latest report on the trends in Hague Convention. I mean, some countries don't get that many. I think in Australia, the last time there was about 35, say, Hague Convention applications in a year. It's a lot more than that. I mean, it's well over 100 a year in England and Wales.
Yeah. Yeah.
But then you've also got to factor in the cases that no one knows about, that don't go into the statistics. A case, for example, where the central authority gets involved, and it never goes to court because the mother, say, might get told, you're going to have to go back, you don't have a leg to stand on.
Yeah.
And so she and the child just go back.
Yeah.
Those will never go into the statistics.
Yeah. Do you work globally then now, trying to spread as much awareness as possible, doing your job and research?
I mostly work in England and Wales for the Hague Convention stuff. So what I should say most importantly is that 2 years ago, the fantastic group Hague Mothers was formed. It is a Filia legacy project, so it's funded by the large feminist organisation Filia. And it's managed by our full-time amazing coordinator Ruth. And when Hague Mothers started, we covered the UK, Australia and the US. So I'm the the UK lead on the Hague Mothers International Strategy Group for the UK. Now we've included New Zealand. We're getting increasing Brazil. So it's sort of increasing through Europe as well. And of course, by its nature, the Hague Convention is an international instrument. So I do a lot of work with researchers in like the US, Australia.
So are you jumping in and out of the country quite a bit then?
No, it only looks like it. No, I never go away, but no, it just so happens that last month there was a big conference on parental alienation and domestic violence in Canada, which was the end conference of a 4-year research project led by Professor Simon Lapierre in Ottawa. So I went to that. But after that, there was, and this is the first of its kind, a historic forum on the Hague Convention and Article 13b. Article 13b is the grave risk defence and domestic violence, which is something that arose from discussions between Hague Mothers and Global Arc. Global Arc is an organisation that supports stuck parents and so on, with Dr. Bernasconi, who is the Secretary General of the Hague Commission. And he became concerned to hear about the problems for victims fleeing domestic abuse. And that resulted in this forum, the first of its kind, which was held in South Africa last month, where there were representatives from Europe, from UK, from numerous other jurisdictions, and we all gathered together, central authority representatives, government reps, researchers, most importantly, some Hague Mothers themselves were there to discuss this issue and what can be done. And it was an amazing venue. And hopefully this is now going to be starting to raise awareness and lead to some positive practices, some positive changes. I can say that we had 2 of our senior UK judges came to the forum, and they were amazing. They do have a very good, really sympathetic and astute understanding of the issues.
There's still a lot of work to do, though, isn't there?
Oh gosh, this is just the beginning. The forum was a lot of work. I can tell you. I bet. But if anyone wants to know more about the Hague Convention, please Google Hague Mothers. On the website, there is a lot of information. There are podcasts with Hague Mothers themselves. There's a lot of resources. And there are also a whole range of very short and accessible expert papers, which we wrote for the forum. So if anyone wants to find out more, please go on the Hague Mothers website.
Thank you so much for explaining everything. And it's been lovely and amazing to chat to you. We've just all got to...
It's been great. Thank you so much. I could go on forever, but I'll stop now.
We've all just got to keep doing what we're doing, haven't we? And just keep going and fighting for change, ultimately.
Of course. And there are lots of, fantastic researchers who are working away in this area. Research groups like SHARA. There's lots of other organisations who are doing terrific work in this area, Survivor Family Network, and together, everyone working together.
I think that's. I think for me that's a biggie. That's a biggie. I think collaboration is much stronger. Us all coming together is going to get a bigger impact into.
I believe so. There have been. I should just mention before we go. Of course, the Domestic Abuse Commissioner has done amazing work. Everyone should read her 2023 report. And I think with all these agencies, as I say, I'm being optimistic and think I'm seeing the glimmer of some real cultural change starting to develop, but it'll only do so if we all keep going.
Yes, yes. I wish I could say the same because we're not seeing that on the ground at the moment.
I know.
But we have to just keep going. We just have to all keep going.
I know.
Again, thank you so much for your time. And hopefully we'll speak again soon.
Yes, and thank you very much for having me on the podcast, and thanks for all the work you're doing. It's amazing.
Thanks a lot. Speak to you later.
Okay.
Bye.
Bye.